Alright, if I'm not mistaken, this is going to work adequately. A little before 2 o'clock p.m. on October 21st, 2022. Reading a motion on failure to establish title written at and sent at 4:08 p.m. Central Standard Time, October 21st, 2021. Samuel Ellsbury Trust 2019, Edna Elizabeth Ellsbury Trustee versus Charity Colleen Crouse, the Northern District of Texas, United States District Court, case number 3:21-CV-2126-K. Motion on failure to establish title. Appellant Charity Colleen Crouse requests judgment to award her deed per Texas Rules of Civil Procedure, Rule 730, failure to establish title, against Samuel Ellsbury Trust 2019. In regard to Samuel Ellsbury Trust 2019, Edna Elizabeth Ellsbury Trustee versus Charity Colleen Crouse, case number 3:21-CV-2126-K. In more than 60 days, plaintiff has failed to establish any legal claim to real property of concern in the case. Evidence that is available in considerations regarding discovery per Texas Rules of Civil Procedure, Rule 193, written discovery, response, objection, assertion of privilege, supplementation and amendment, failure to timely respond, presumption of authenticity, and in void of the applicability of Texas Rules of Civil Procedure 192.4, limitations on scope of discovery, show the public records recorded with the County of Dallas demonstrate that Samuel Ellington Ellsbury III did engage in fraud and deceit by misrepresenting his interest in the real property at the time of meeting Charity Colleen Crouse in May of 2017, and instead extended a bad faith effort to defraud her of a homestead claim that was first substantiated via verbal acknowledgement in July of 2019. See affidavit and motion to transfer to federal district court. The proof of this fraud regards a special warranty deed, document number, and it has a document number, recorded on December 5th, 2019, from a previously undisclosed deed holder 6 months after Charity Colleen Crouse became domiciled at the location. Additionally, evidence demonstrates that the bad faith engagement with intent to defraud Charity Colleen Crouse was used in a violation of Charity Colleen Crouse's good faith efforts at making improvements to the property, including after Samuel Arrington Ellsbury III acknowledged breaking down the door and refusing to repair it for over a year, necessitating Charity Colleen Crouse purchase her own lock to her room in order to establish safety and in consideration of professional needs associated with her home office work production. The transfer of the right to access to Charity Colleen Crouse per the issuance of a 4-digit key code to the door that Charity Colleen Crouse was told was for her only. Samuel Arrington Ellsbury III was given a separate code, and that no one else but Samuel Arrington Ellsbury III and Charity Colleen Crouse had use of those 2 code keys for the door, substantiated exclusive right of access to Samuel Arrington Ellsbury III and Charity Colleen Crouse, hence any access by anyone else was either as a guest of Samuel Arrington Ellsbury III or Charity Colleen Crouse. Charity Colleen Crouse did not permit access to anyone else outside of one instance connected to a request that documentation and authentication of legal relationship of any real property claim be produced in regards to transportation of chemicals kept on site in a safe location that was set aside, inventoried, and secured behind lock and key until such time as legal and appropriate disposal was available. See affidavit. Refusal to provide documentation and to relinquish rights of access solely to Samuel Arrington Ellsbury III and Charity Colleen Crouse was de facto and formal acknowledgement of Samuel Arrington Ellsbury III and Charity Colleen Crouse's exclusive right of access, as well as possessory interest in the property. Additionally, until this time, no judgment in the alleged eviction proceeding has been produced. No information on bond has been provided by the plaintiff. No information on costs associated with what justified illegally seizing personal property and work products, including personal identification documents that until this time are illegally in possession of another, has been produced, and no confirmation of any alleged costs associated with legal fees, as was requested in the alleged petition for eviction, has been provided. As such, plaintiff has forfeited claim to defendant per Texas Rules of Civil Procedure, Rule 730, failure to establish claim, which states, quote, where any claimant has obtained possession of property and ultimately fails to establish his rights thereto, judgment may be rendered against him and his sureties for the value of the property, legal interest thereon from the date of such bond. Such judgment shall be rendered in favor of the plaintiff or defendant in the writ, or one of several plaintiffs or defendants, if more than one, and shall fix the amount of the claim of each." End quote. No bond or informational bond was provided to the Justice Court, and no confirmation of such bond was provided to the defendant. Defendant provided what would be necessary to secure bond according to legal requirements via her affidavit that was dated for August 30th, 2021, and provided as an official original document in Justice Court on September 3rd, 2021 to Judge Juan Jasso, Attorney Kim Sims, but refused by the clerk of the court with a referral that also reaffirmed the pronouncement by Judge Juan Jasso in the proceeding that appeal could be either with the clerk of the court on site or as needed downtown. Defendant filed her appeal to the Northern District of Texas U.S. District Court on September 7, 2021, and has persisted in a good faith effort to engage legal action per the terms of Article 16, Section 50 of the Texas Constitution. Defendant has also substantiated allegations of the bad faith effort of the Samuel Ellsbury Trust 2019 and intent to engage her in a scheme to defraud. Burden for production of evidence as already listed in the course of her appeal to the Federal District Court falls on Edna Elizabeth Ellsbury as the only named plaintiff alleged to represent the Samuel Ellsbury Trust 2019, and in light of the fact that she engaged in unlawful proceeding to break and enter the property and illegally seize evidence and property from defendant. No legal right to access has been established, and neither has a legal claim to the real property wherein it was located been established. Even if there was a legal cause of action to possess the real property, which there is not, then there is no legal right of Samuel Ellsbury Trust 2019 to illegally possess personal identification documents of the defendant, including government-issued documents, and to evade the law in the course of this proceeding when it comes to production of documentation legally justifying an action against the defendant. Continued possession of these personal identification documents, as well as the refusal to produce evidence that was already declared on the record prior to the illegal possession, gives credence to charges of securities fraud and other criminal violations of law, as alleged in the original motion to remove the Federal District Court September 7, 2021. Additionally, defendant requests the court to compel production of verification by the Justice Court in consideration of Texas Rules of Civil Procedure, Rule 629, requisites of execution, regarding the time frame in which the plaintiff expected the return from the Justice Court on the writ in response to charges of an effort to engage in illegal derivative action against defendants LLC, as stated in the original motion to remove the Federal District Court, and in response to accusations of efforts to engage the defendant in an illegal effort to proceed in the course of a judgment lien on homestead property, including insofar as additional loans or efforts at mortgage or other activity have been engaged in connection with the real property during the time frame in which this unlawful proceeding has been engaged. Further consideration is requested of the original allegations of violations of Section 16 of the Texas Constitution, bills of attainder, ex post facto law, retroactive laws, impairing obligation of contracts, in consideration of the fact that the bad faith actions by Samuel Arrington Ellsbury III make appropriate consideration of the legal implications of the real property arrangement as applicable from July of 2019, at which time Samuel Arrington Ellsbury III first acknowledged homestead claim by Charity Colleen Crouse before the changes to Texas law that went into effect on September 1st, 2019, and before the recording with the County of Dallas of a transfer of deed from Martha Ellsbury to Samuel Arrington Ellsbury III as of November 25, 2019. This notice of transfer is the only legal recording of deed available and contradicts the testimony provided by Edna Elizabeth Ellsbury at trial on September 3, 2021, as well as the alleged arrangement for real property when Samuel Arrington Ellsbury III first engaged with Charity Colleen Crouse in May of 2021. Information on the value of property is on site at the property, including receipts, inventories, invoices, and other financial and asset information, such as original documents of incorporation and official tax statements. The burden of proof for production of these items is on plaintiff per Texas Rules of Civil Procedure, Rule 728, burden of proof, and continued refusal to produce them is requested for consideration and computation of interest on a daily basis per day that it is unlawfully refused production. Defendant discloses, however, under Federal Rules of Civil Procedure, Rule 26, duty to disclose, general provisions governing discovery, A1A1, that evidence has come to light, including as substantiated in other evidence that is on site at the location and is in plaintiff's possession in violation of the law, as well as additional evidence. If there is rightful cause of action to pursue a claim regarding a similar effort that defendant alleges is connected to the current proceeding regarding a scheme to defraud defendant from her first arrival and procurement of a lease for real property in Houston, Texas from July of 2005. That cause of action may entail application of Texas Rules of Civil Procedure 728 in consideration of the burden of proof by the state of Texas. It also involves an attempt to engage a scheme to defraud another person. That claim will be presented in another case filing effort through the appropriate court of jurisdiction, but invokes consideration of U.S. versus Felix 926 F2D 1522, February 28, 1991, regarding, quote, same evidence can be used to prove more than one charge, end quote, as cited in List of Evidence, Evidence List 2, motion to add exhibits to Evidence List 2, and Evidence List 3. There's an oath of attestation. You can see. I printed out this on the day. I sent it electronically. I signed and dated it. I printed out more than one version. There were 3 originals that were printed out for a specific reason. This one was printed out today. It is not the only copy that was printed out, again, for another specific reason. At this time, I'm going to leave this as it is. I will only say that within the last 72 hours, I have reviewed cases, including cases that became available in the course of evidence that became available, that take this claim all the way back to 1843 and have very specific implications, including in connection with allegations in here. But that there is also an understanding that more evidence has become available, including in consideration of my request for consideration of Federal Rules of Civil Procedure, Rule 26, duty to disclose general provisions governing discovery, and other evidence has come to life, not only since the time of this filing, but in very important time frames since then, including in connection with April 1st of 2022. Today's October 21st, 2022. If I'm not mistaken, it is before 4:08 p.m. Central Standard Time. My name is Charity Colleen Crouse.